Supreme Court quashed and set aside the order in the matter of Pushpa Jagannath Shetty versus MS Sahaj Ankur Realtors and others, holding that the NCDRC has committed error on face of record. Supreme Court said that we hold that the complaint filed by the appellant was within time and the same was restored to its status and number. And it also directed the parties to appear before NCDRC on 17 March 2025, and it requested that the matter be decided expeditiously and preferably within 6 months. The appeal was under Section 67 of Consumer Protection Act 2019 and directed against judgment dated 14 March 2023 passed in consumer case number 238 of 2019 by NCDRC Delhi. Short facts giving rise to the appeal were that the respondents were a partnership firm that owned building named Madhav Bog in the village of Andheri, Mumbai. Complainants were tenants in two flats on ground floor in building A. Former decided to demolish this building and construct a new one, and in furtherance thereof executed permanent alternate accommodation agreement dated 20th September 2013, allotting flat number 801, carpet area 700 square feet on 8th floor of B wing of new building. Agreement provided 24 months from date of issue of commencement certificate along with grace period of 6 months to complete such construction. Proposed redevelopment, however, could not be completed in stipulated time as such on 10 January 2015. The respondents executed an indemnity cum undertaking to allot two flats number 301 and 302 having carpet area of 650 square feet and 667 square feet in B wing free of cost if necessary. Approvals could not be obtained within 6 months. This agreement further provided that if respondents failed to give either of the two options to appellant, they would be entitled to compensation for 1317 square feet carpet area at market value plus 25% additional value. Vacant possession of old flats was handed over in December 2014 and necessary monetary consideration for alternative accommodation should transfer to appellants within time. Contractual period of 24 months expired in December 2016. Respondent continued payment of rent of alternate accommodation of appellants at applicable rates till January 2019. Balance of dislocation compensation, that is 2,50,000, remained pending thereafter. Several letters were exchanged and meetings were held between the parties. Appellants wrote a letter dated 13 August 2008 to Mahesh Jani, solicitor and escrow agent, asking him to hand over papers of this flat in escrow to them. In meeting on 26th September 2018, respondents were informed that the approved layout, if that was not produced, flats put in escrow could be released to appellants. Further time was sought on two occasions, but flats in escrow were finally released to appellants on 17 December 2018. In facts above, arises for consideration pertaining to calculation of limitation preferring the complaint case. According to impugned order, 6 months were required to be counted from date of indemnity come undertaking. Flats in escrow were to be given requisite permissions which could not be obtained within period of 6 months. Hence, cause of action arose on 10 July 2015. Complaint case came to be filed on 19 February 2019. As such, same was barred by limitation. Supreme Court said that with regard to implementation of terms of contract, there was no question of dismissal of complaint on issue of limitation. It was continuing cause of action, and only when escrow expressed helplessness that complainant was forced to file the complaint. The stand of NCDRC defeats the ends of justice in this case. Initial cause of action arose in July 2015 after 6 month period expired. However, court cannot be amiss to the fact that parties had been pursuing the matter with respondents by way of letters, meetings, and even with escrow agent who did his own back and forth with the owner before finally releasing the flats in escrow in favor of appellants. Further, as can be seen from reliefs extracted, what has been claimed is the security of the title they received upon respondents' default. Complaint case has not been filed seeking flats in escrow for which cause of action did arise on 10 July 2015, and hence same limitation cannot be applied to subsequent situation, which is that the appellants already have flats with them. They only seek the same to be registered their name and not alienated to any third party henceforth. Limitation, while important as feature of law, is not meant to defeat substantive right. Efforts in earnestness to secure possession of flats cannot be discounted in order to compute applicable limitation. NCDRC ought to have taken a holistic view of situation and then proceeded to examine whether the relief as claimed may be granted in favor of the appellant.